water with especially here in Texas, is a big deal, right? And produced water specifically has been the subject of litigation since the Permian really blew up, and companies and operators evolved their and advanced their use of wastewater, traditionally wastewater, and essentially they've turned that wastewater into a viable, product that they can, reuse, market, sell, extract things from, and all of this kind of produced lithium through produced water and salt water and brine, and then all the work, the refrac work that happens, the recycling of produced water. It's just becoming more and more of a thing that as a landman you need to really understand. And so I was reading through the kind of the top cases of the year in the most recent Landman magazine, and it had this Cactus Water case. And just as I was going through it, I thought, well, okay, well, how does that apply to, ownership of constituent minerals from produced water? And so I thought it would be just a great conversation to talk to Bobby. He published a number of really informative articles on Cactus, that case, and the effects that it has, and just overall produced water. So he's a great resource for the layman community to kind of understand that and really dive into some of the nuances that you might deal with. And so figure we would start there and just really talk about that case and what we're seeing and some trends that we're seeing in produced water in the Permian Basin and Eagle Ford and things like that. And then maybe if we got some time, we can transition into how, the lithium space and extraction of lithium through brine and what we might expect there. There's a lot of questions up in the air as to how we should interpret that and just take it from there. So that's what got us here. We want to revisit it a little bit.
Sure. Yeah. Glad to talk about it.
So can you just give us a general rundown, Bobby, on this case, on the Cactus Water case?
So Cactus Water is coming, and really kind of the part that's interesting for us is the part that's coming out of the Court of Appeals in El Paso. This is a case out in Reeves County where essentially Concho as the mineral lessee under about 37,000 acres, and it's across 3 different leases that are kind of controlling. And then this company called Cactus Water comes in and does essentially a produced water lease on top of that. So these are leases that are about a decade old when this kicks off, and then Cactus Water comes in and leases same kind of 37,000 acres, and essentially it was, we want to pay you a royalty on your produced water if and when we can monetize it. And this is really one of the, I don't know either side, the parties in either side in terms of like personal relationships there, but it seems like one of those cases where sometimes you are effectively buying a lawsuit. And it seems like that's essentially what Cactus did in this case, is to go in and challenge some of these rights. But Cactus's position was water is historically been a surface element. It's something that belongs to the surface estate owner. These leases leased the oil, gas, and in one of the leases, it was oil, gas, and other hydrocarbons. And then another one was just simply oil and gas. Their position was that's not water. It's not water of any form. And so we're going to lease on top of that and then try and monetize that produced water as it becomes a more necessary resource and as technology continues to advance to treat it. Ultimately, it went up to the court of, competing summary judgments got filed in the trial court. They found it in favor of Concho, goes up to the Court of Appeals, and 2 of the justices in favor of Concho and affirmed that decision. And then one of the other justices, Fox, filed a pretty lengthy and respectful but scathing, basically saying they're wrong. No, this belongs to Cactus. This belongs to the surface owners. And then we're just kind of waiting to see if and when the Supreme Court's going to take it.
So Cactus Water secured their leases. And who sued who? Did Cactus Water then immediately sue Concho to say, hey, we are entitled to access to your produced water?
Cactus put Concho on notice and it effectively said, we're entitled to your produced water. You're taking our rights under this agreement. And then I believe it was Cactus that filed suit first. They filed what's called a declaratory judgment.
Okay.
And so we have these competing documents and we want a court to interpret them and to determine what our rights are under both of them.
Okay. And so as far as the results, you had a 2-1, and now it's being considered by the Texas Supreme Court as to give a final judgment on it.
Kind of. So in Texas, not too dissimilar from in federal court with the United States Supreme Court, there's very limited automatic rights to appeal when it comes to the final Supreme Court. So 2 justices found in favor of Concho, 1 dissented, but because it's 2-1, the lower court's decision was affirmed. Concho wins, and then you have to file what's known as a petition for review with the Texas Supreme Court to see if they'll even
Take the case.
even take it. Yeah.
So, Bobby, what this means, just to kind of summarize on it, if this holds, if the Supreme Court doesn't take up this case, if it would leave us all with the understanding that if you are an oil and gas operator that is producing, that you have the executive rights to monetize, to do whatever you need to do or can potentially do with that produced water. And if
I wish that was true.
okay,
And so within the legal space, it gets a little bit confusing because technically, if the Supreme Court doesn't take it up, then yes, that is the decision in the El Paso district. And so there will be controlling precedent there, but that's not necessarily going to be controlling in other areas. So it wouldn't be controlling. It's informative, and it's unlikely that lower courts would go against it, but it is only, it's informative, and it has some value in East Texas, where this is going to be a huge issue with all the brine extraction. But until we get an official Texas Supreme Court ruling, there's not going to be any uniform law across the state.